Okay, so I was listening to the Sabrina Salvati show, and she was addressing some comments made by Justice Ketanji Brown Jackson regarding the First Amendment. And I want to address this because I've been bringing up to you all about the issue of judicial supremacy, that we're supposed to have co-equal branches of government, but really we don't have three co-equal branches of government because the Supreme Court, or the judiciary in general, does have the final say when it comes to the law. So although we have the Constitution, the Supreme Court has made exceptions, and their analysis really curtails your ability to exercise your constitutional rights. And I mean, I've talked to you all about the level of scrutiny that applies under an equal protection analysis, a substantive due process analysis, and a First Amendment analysis. It's the same. It's the same analysis. It's rational basis, intermediate scrutiny, and strict scrutiny. So I'm going to play this clip, and then I'm going to explain it as we get through it.
I want you to hear what Justice Ketanji Brown Jackson argues in this case when it comes to the First Amendment. Now, remember, this is the person that Joe Biden selected, and everyone said, a lot of people said kudos to Joe Biden because he chose a black woman. And I was one of the people that said, okay, yeah, she's black, but what is she for? And people just kind of gave me looks and stares. I'm like, oh, how dare.
And I expressed similar concerns. I actually did a video about it. I wasn't too clear, but I felt like she kind of got rushed, and everyone was focusing on the fact that she was a woman and the fact that she was black. But I wanted to hear more about her her history as a judge and as an attorney. And I felt that it was kind of rushed through, and then any type of pushback was really viewed as sexist or racist. So yeah, I wasn't too enthusiastic when it came to her, but at the same time, I'm not enthusiastic about any of these Supreme Court nominations. When it comes to diversity on the U.S. Supreme Court, I'm more interested in diversity of religion as opposed to race or gender. For a long time, pretty much all Supreme Court justices have been either Catholic or Jewish. Ketanji Brown Jackson was the first Protestant in a very long time. And I have actually written Obama requesting that he nominate either a Muslim or an atheist. The response that I received was very generic. It seemed like somebody had copied and pasted it from a previous letter, because their response was unresponsive to what I said in my letter. But I will give them credit for at least responding. What I will say about the Trump administration is that when I wrote the Trump administration, maybe 2 or 3 letters, I never received a response at all.
How dare you? How dare you? It's about representation. Representation is great, but who is she for? And I argued back then she would be for corporate interest. I said if Joe Biden selected her, she's not going to be for a progressive view. She's not going to be for a lefty view, a socialist view. She's not going to be for the people. She's going to be for the corporations and the military industrial complex and censorship. We'll go into the first audio here because it appears I was correct about her. So shout out to Glenn Greenwald for capturing this.
And I'm not even going to say what I said about her. That video, I think it may still be available, but yeah, I had some choice words for her. I wasn't too happy with that nomination.
It says Ketanji Brown Jackson grills Louisiana. Ketanji Brown Jackson grills Louisiana Solicitor General, says that because the government can occasionally censor, they can also occasionally coerce. Listen to this, guys. I can't make this up. This is wild.
But whether or not the government can do this is something I took up with Mr. Fletcher, depends on the application of our First Amendment jurisprudence. And there may be circumstances in which the government could prohibit certain speech on the internet or otherwise. I mean, do you disagree that we would have to apply strict scrutiny and determine whether or not there is a compelling interest and how the government has tailored its regulation?
Certainly.
So notice that she used the phrase strict scrutiny, because that is the analysis that you would apply when it is content-based restrictions on the free exercise of speech. If it's not content-based, if you're just, you can regulate, the government can regulate time, place, and manner, right? They can say, well, you can only do it at this time, or you have to do it in this way. If it's not content-based, then a strict scrutiny analysis doesn't apply. And just to be clear about what strict, okay, let me go ahead and tell y'all what it is. Rational basis mean, so, okay, so again, first of all, the First Amendment is not absolute, right? It just depends on the type of regulation that will determine the type of analysis that you're going to apply. So rational basis means that the regulation, even though it's discriminatory, it can still pass constitutional muster. If it's not content-based, it has to be rationally related to a legitimate government interest. I don't think intermediate scrutiny applies, but it does apply when we're talking about equal protection or a substantive due process right. And that would, it's a little bit higher than rational basis. It would have to be substantially related to a legitimate government interest. And then strict scrutiny, which is what would apply to content-based restrictions on free speech. It has to be substantially related to a compelling government interest, and it has to be narrowly tailored. So it's not saying that there can't be any restrictions on speech. It has to be a compelling state interest, and it has to be narrowly tailored. Now, most restrictions on free speech are going to fail under that analysis, but there are limited exceptions where the restriction could pass constitution. And again, this is based on something that the Supreme Court concocted. This isn't based on a constitution itself. The Supreme Court is the final say when it comes to the law. So a lot of these doctrines were created by the Supreme Court. This is nowhere in the Constitution, but most attorneys, I would say all attorneys, have been indoctrinated to believe that the law is whatever the courts say it is. So this is the reason why I would never hire an attorney. They're officers of the court, and this is what they believe.
Your Honor, I think at the end of every First Amendment analysis, you'll have the strict scrutiny framework in which, you know, in some national security hypos, for example, the government may well be able to demonstrate a compelling interest, may well be able to demonstrate.
All right, so not every situation in which the government engages in conduct that ultimately has some effect on on speech necessarily becomes a First Amendment violation, correct?
Maybe not necessarily, Your Honor. I guess the top line question I would ask is, has the government set out to abridge the freedom of speech? And in this case, you see that time and time again, because if you control
that's not the test for First Amendment violations.
Your Honor.
So if you notice, he didn't really push back, because he's an attorney. So this is what you learn in law school, that there are limitations to the First Amendment. And this is something you would be tested. I mean, no, the First Amendment is not really going to come up on a bar exam, but yeah, the bottom line is that attorneys believe that the law is whatever the courts say it is. So the courts get to create these judicial doctrines that the public is not aware of, and they think that they have these absolute rights, and they don't. The Supreme Court has put limitations on your exercise of constitutional rights.
So notice how she interrupts him here. She is honestly arguing for the fact that the government should be able to bypass the First Amendment.
I mean, to be fair, that's not really what she was saying. What she was saying is that she knows the analysis, that the strict scrutiny analysis would apply to content-based censorship. And what she's saying is, don't tell me what the analysis is. I know that I'm a Supreme Court justice, and I'm an attorney. I passed the bar exam, so you don't need to school me on what the analysis would be under that circumstance.
And push back on the First Amendment. Why do we have a First Amendment? Why do we have a Second Amendment? I feel like these rights, or our rights in this country, are just being chipped away like little by little. Like
That's because of the doctrine of judicial review. The Supreme Court gets to define what the Constitution is, and there's really nothing that anybody can do. Remember, I was telling y'all about what was I just talking about recently about preemption. I was talking about the right to die, and how they didn't want the Supreme Court of Massachusetts to define a constitutional right, or declare a constitutional right to die, because that would preempt the legislature. That is because of judicial supremacy. The judicial branch has the final say. So if they declare something to be their interpretation of the Constitution has the same legal effect as the Constitution itself.
This is insane. And this is dangerous. Because think about it, people are sitting back and they're like, well, she's, liberal, and Joe Biden's the president, he's Democrat. That won't always be the case. The decisions that the Supreme Court makes, it doesn't matter who the president is. It doesn't matter if the president's a Democrat or a Republican.
I don't think it's about liberal or conservative. I think it's really more about whether you believe in limited government or big government. And I think a lot of people flip-flop on that. They're big government when it comes to liberty interests, but then a lot of these Democrats are big government when it comes to regulating private commercial activity. So, yeah, I don't think anybody's really limited government. Absolute power corrupts absolutely. So when they get in these powerful positions, they want to maintain it. They want to be the ones to say what is and what isn't. So, yeah, the bottom line is there needs to be checks put on the judiciary, because the judiciary is running amok. There are checks put on Congress, and there are checks put on the president. There are no checks being put on the judiciary. They don't get impeached. There are no ramifications for the judiciary violating the Constitution or not upholding their judicial responsibility. So, what I will say about Trump is that we did see some pushback. He was giving smoke to Justice Ginsburg. We have never seen that in recent history. We've never seen any sitting president do that, because on the Democratic side, most of these presidents have been attorneys, right? Obama, I believe Joe Biden, Bill Clinton, George Bush wasn't, and Trump wasn't. But when it comes to Democrats, most presidents are going to be attorneys.
So to me, it's just like, this is very dangerous.
This flows from the plain text of the First Amendment, right?
No, I understand, but we have a test for a determination of whether or not the First Amendment is actually violated. So in certain situations, the government can actually require that speech be suppressed if there's a compelling interest, right?
No. So she just said the government, in certain situations, the government can actually push for speech to be suppressed. In what situations? And who decides what those situations are?
Okay, so now I'm going to answer that question. So here's I know this, but for me to go off the cuff, I would rather read from, this is the Congressional Research Service, and this really summarizes case law. The First Amendment's free speech clause prohibits the government from suppressing or requiring adherence to particular ideas or messages. This is referring to the First Amendment. The Supreme Court has recognized that laws restricting or compelling speech based on its content have the potential to expel certain ideas or viewpoints from public debate. The court typically regards such content-based laws as presumptively unconstitutional, right? That's what I was trying to tell you. It's subject to a strict scrutiny analysis, which usually is going to fail, but there are exceptions to it. It's not absolute. To determine whether a content-based law passes constitutional muster, courts generally apply a legal standard called strict scrutiny, under which the government must show that the law is the least restrictive means of advancing a compelling government interest. So that's what I was telling you before. It has to be, there has to be a compelling state interest, and it has to be narrowly tailored. The government rarely prevails under strict scrutiny. A law that regulates speech can be content-based in two ways. A law can discriminate against certain content through its text or through a discriminatory purpose. Both forms of content discrimination typically trigger strict scrutiny. Like the government can't tell you to say certain things, or they can't limit certain viewpoints, but they can regulate time, place, and manner. That is subject to rational basis. A law is facially content-based if its text applies to speech based on the subject matter, topic, or viewpoint of that speech. In facially content-based law, the law's application turns on the substantive message conveyed by the regulated speech, rather than a content-neutral factor such as the speech location. Right? That's why I was trying to tell you, time, place, and manner. For example, the Supreme Court ruled that a town ordinance was content-based on its face because it restricted political signs more than ideological ones. In contrast, the court held that a city sign code was facially neutral, where the law placed greater restrictions on off-premises signs advertising businesses or events at another location than it did on-premises signs, right? Time, place, and manner. They're not telling you can't say certain things. They're just telling you where you can post a sign. Even though enforcement in both cases would have required authorities to read the sign's message, that is, to know their content, the second law signaled out signs based on the location rather than subject matter. It was therefore facially neutral. Excuse me. While laws restricting speech are sometimes content-based, laws that compel a person to communicate a particular message are nearly always content-based because they alter the content of that person's speech. Yeah, I just had a recent situation with the police where they tried to compel me to say something against my will, and I'm fighting that in court. Anyway, laws such as labeling and disclaimer requirements that require private entities to disclose certain information to the public or the government may be considered to compel speech and are usually content-based. There's certain things they can compel you to say, like they can compel you to identify yourself. They can compel, very limited circumstances, they can compel you, but they can't compel you to say something that's viewpoint based or content. Like, I may do another live stream to tell y'all what the police were trying to convince me to say and why it was completely content based. Even if a law is content neutral on its face, it might be considered even if a law is content neutral on its face, it might be considered content-based if it reflects a discriminatory purpose. That is, if it cannot be justified without reference to the content of the regulated speech or was adopted by the government because of disagreement with the message conveyed. For example, in 1990, the Supreme Court dismissed a prosecution under a federal statute prohibiting flag burning. Flag burning is considered expressive speech. So yeah, that's protected. The statute did not contain explicit content distinctions, for example, by prohibiting flag burning as a political message, but allowing it for other purposes. The court nonetheless concluded that Congress impermissibly sought to suppress the communicative impact of flag destruction in order to preserve the flag's symbolic value, a content-based justification for the law. You can burn the flag. They can't restrict that. The court considers viewpoint discrimination to be an egregious form of content discrimination. A law discriminates based on viewpoint when it regulates speech based on the particular ideology or opinions expressed or favors one side of a debate over another, as opposed to regulating speech about a general subject matter or topic. There are some limited contexts in which viewpoint-based distinctions are permitted, such as when the government itself is the speaker. Yeah, they do regulate. If you're a government employee, you can't convey speech when you're speaking in your official capacity. In your personal time, you can say certain things, but I know when I was in the military, there were certain things we weren't allowed to say because, you know, I was in uniform. So even in sometimes they tell you can't speak to the media or whatever because you would be speaking on behalf of the governmental entity, and they don't want you to do that. So I just want to get into the exceptions to the strict scrutiny analysis. Here are the exceptions, right? Obscenity, true threats, and speech integral to criminal conduct. However, any further content-based distinctions within these categories would trigger strict scrutiny analysis unless the basis for the content discrimination consists entirely of the very reason the entire class of speech at issue is proscribable. I mean, this is more complicated than what I'm going. I took a whole class on this when I was in law school. There's even like things that are of prurient interest, they can restrict it based on time, place, and manner. This is the reason why they can serve certain content during the day. This is the reason why adult video stores have to be zoned out. Yeah, it's not absolute. And to answer the question, who decides which speech can be suppressed is going to be the courts. The legislature or the municipality, whoever passes their laws or their ordinances, and then you would have to challenge it, alleging a First Amendment violation. And then they would go through the analysis, and then it would go through a trial court. You can appeal it. And because it is a federal issue, really you can take it straight to a district court, because a federal district court, because it's a federal question. You don't even have to go through state court. It is a federal issue. Therefore, the federal court has federal question jurisdiction. So I hope that answers the question. It's up to the courts. It's and I don't think, I mean, the courts don't always follow the law properly or correctly, but that's your resort to, I mean, appeal it to the highest court, which is going to be the Supreme Court. And if they're willing to take your case, then maybe you can get the law overturned. But other than that, most of the time, the highest judicial review that you're going to get is going to be with the Court of Appeals. So hope that answers your question.